Good morning and Happy New Year. Well, today is it's January 2nd, so hopefully everybody is excited about the new year. I know that I am. 2015 I think is going to be a very promising year, not only speaking personally and professionally, but I think for our greater economy and our real estate economy. So I'm usually filled with optimism around the new year, New Year's Day and thereafter, but this year I feel that even a little additional optimism. At least that's the way I'm feeling. But I launched right into my feelings, and I didn't even begin by introducing myself. My name is Len Foy, and I'm a real estate attorney in Nashua, New Hampshire. For those of you who have been watching my videos, we have created and posted a series of videos informing people about purchasing real estate, and I'm a real estate attorney and how I might be able to assist people and represent them and the benefits to using my office. We've covered a range of subjects, a diverse range of subjects, deeds. We've done a video on buying bank loan properties, tips for buyers, tips for sellers, the closing process, title insurance, and we're just going to continue to make these videos and to try to cover additional subjects. And because I'm a real estate attorney, people frequently will ask me, at cocktail parties and barbecues and events and gatherings with friends and family members, what piece of advice can you give me? I'm purchasing a piece of property, or we're getting ready to put a property on the market. What piece of advice can you give to me? And it occurs to me that by virtue of specializing, as I do, or having a concentration in real estate, and because I've been practicing real estate law for so long, I've been practicing as an attorney for 20 years, and in all that time I've been assisting clients with real estate matters, both commercial and residential. So I consider myself to be very experienced. And so what I thought I would do today, we're going to try to keep it brief, which we always fail to do, or I always fail to do, but I'm going to try. But I'm going to try to just identify 5 tips right out of the gate for the New Year's. 5 tips for buyers and sellers of real estate. I would say this is more residential, but certainly most of what we're discussing here this morning could apply in the commercial context as well. So I'm going to offer up 5 wonderful tips for buyers and sellers of residential real estate to start the new year off right. And certainly if anyone has any questions or would like a free consultation or would like to talk to me in greater detail about the content of this video, I'll close with some contact information for myself and my firm. So the first tip for buyers and sellers of residential real estate in this 2015 video is probably the tip that I feel the most passionately about. Hire a lawyer to represent you. I can't stress that enough. People have all kinds of excuses as to why not to use an attorney for a particular task or endeavor. And I understand that. And I'm the same way. It's expensive. It's usually outside of people's budgets. Most people are working very hard for a paycheck or paychecks, and there is just simply not enough room in the family budget to pay a lawyer some ungodly amount of money to work on something. But what I would tell you is that most people don't realize that real estate legal services are probably the most affordable legal services going. So whereas the traditional divorce, these things are very expensive. We know anyone that's been through that process or knows somebody who has, knows that can be thousands, sometimes tens of thousands of dollars in legal fees. I'll say this: I'm always reluctant to quote fees, especially in a sort of a generic, all-purpose context such as this. But I can tell you that what I like to tell people is that legal services for real estate attorneys is typically hundreds, not thousands of dollars. So maybe that will put it into some kind of context right out of the gate. And if you work with an attorney on sort of an a la carte basis, so you might say, well, I'm not going to use you for the entire process because it would be too expensive, but I'd like you to handle reviewing the purchase and sales agreement for me, or I'd like you to attend the closing with me, or I'd like you to help me navigate this one area of difficulty that I have with the buyer or the seller or my realtor or the other lawyer or whatever it might be, then it would be even more affordable for you. So if you're buying real estate in New Hampshire, Massachusetts, Maine, or Rhode Island, or if you're selling real estate, I would say my first piece of advice, hire a qualified attorney to represent you in that transaction, either for the entire transaction or for a portion or a piece of the transaction. I think you'll find it's less money than you think. It's all expensive. At the end of the day, it's all expensive. But here's the problem, and by the way, I want to say, and I've said this in all my videos, but I always like to hammer this home. With respect to Rhode Island, I am licensed to conduct real estate transactions in Rhode Island, and I do, but I'm not licensed as an attorney in Rhode Island, so I'm not in a position to provide legal services to Rhode Island residents or to handle legal matters, and I always like to clarify that for everyone's benefit. But here's the problem, or here's the dilemma for the person who says, you know what, I can't justify spending $500 on an attorney to represent me in this transaction. The problem with that thinking, which I understand and support, is that many times it costs a buyer or seller more than that to not have had the services of an attorney. You're going to have to spend money on attorneys anyway. So if you're buying or selling real estate, the attorney or the title company that's handling that transaction will charge buyers and sellers for services whether the buyer or the seller has really opted or signed up for that or not. So I've seen sellers kind of stubbornly say, well, I'm not hiring a lawyer to represent me because I just don't have the money. What they end up doing is they end up paying the attorney or the title company that's handling the transaction. They pay them to provide services and prepare documents which they have kind of ironically vowed not to pay for. But the trouble is they're not paying somebody that represents them, they're paying essentially the buyer's representative to prepare their documents and to perform duties and provide services and to charge accordingly. So sellers are going to pay for those services whether they want to or not, or I should say whether they want to or not, whether they realize they're paying for them or not. So when a seller says, I don't want to pay a lawyer to represent you, well, you're paying a lawyer, you're paying the buyer's lawyer is what you're doing to prepare your deed and to provide other services. So many times buyers and sellers are going to spend a portion of these fees quoted either way. The question is, will they have their own independent legal advocate performing duties and providing services to them, or will they be leaning on the attorney that's handling the transaction who has no allegiance or loyalty to them? So that's the first point. And then, of course, there are other instances which go way beyond, preparing deeds and providing sort of administrative services. But there are other instances where people have opted not to hire an attorney, and it has cost them dearly because of things that they didn't anticipate, because of oversights, because they did not have an independent legal representative. So I've seen situations and instances, many of them in fact, where a seller, and I'm picking on the sellers today, but sellers, I think, buyers have, even if buyers don't have their own independent legal representative, they have the attorney who's handling the closing, who needs to do it in a professional manner, and who they can lean on to provide services to them and almost essentially function as their attorney. A seller that doesn't have an attorney is just very vulnerable. So I think that's why I'm picking on the sellers today. But I've seen situations where a seller made a decision not to hire an attorney to represent them, and it wound up costing them a lot of money because of something that they didn't anticipate, something that they didn't understand in the contract, something that they didn't understand at the closing, and they didn't have their own legal representative. So are you always going to, if you hire a lawyer, will you sometimes perhaps spend a little bit more money than you might have if you didn't have a lawyer? Well, I suppose that's true and possible, but there are many instances where where as a seller or a buyer, you're going to save money. And I just think that, we can't always afford to have lawyers represent us. Wouldn't it be nice if we could have a team of lawyers review every document we sign guide us and advise us through every situation we found ourselves in, both legal and moral and ethical and societal. But the truth of the matter is that for most of us, we just have to rely on our own instincts and our own judgment and our own gut feeling as to what to do. With real estate, that's not the case. For short money, what I would ultimately consider to be short money, you could pay a lawyer to represent you and advise you. If that lawyer makes a mistake, they're on the hook to you. So you will have done everything you can possibly do. They'll attend the closing with you. They'll prepare your deed for you. They'll review documents that you have questions about for you. They'll review the purchase and sales agreement for you and with you. So I've emphasized this point probably too much, but it's just so important. My first tip for people buying and selling real estate: hire a lawyer to represent you in the transaction. Tip number 2, and this is an important one. I don't think that your lawyer needs to review every document that you sign in connection with this process. You're going to sign a purchase and sales agreement. If you're a buyer, you're going to sign 1 million disclosures. You're going to sign a loan application. If you're a seller, you're going to sign a listing agreement. You're going to sign some realtor-related documents. Everybody is signing their life away from the beginning of this process through the end. I don't think you need a lawyer to look at everything you sign, but please, please, please have your attorney review the purchase and sales agreement. Have your attorney review the purchase and sales agreement. That is tip number 2. That is a legal contract. And I cannot tell you how many buyers and sellers that I've worked with, I've become involved in the process after they signed the purchase and sales agreement, who really did not understand the true, the nature and the potential issues raised by the legal contract that they signed, whether it was concerning their obligations, their loan, when are we closing, where are we closing, what am I supposed to do in connection with the closing, what fees am I going to pay in connection with the closing, if there's an assessment or a betterment that comes out of the woodwork, who pays for that? Does the seller pay? Does the buyer pay? Special assessments on condos. The list is really limitless, and a lot of these issues are born within the boundaries of the purchase and sales agreement. That is the first official contract that buyers and sellers will sign together. It is a legal contract. It is, in some respects, it's been made to be understandable, so I think that most people in a position to buy or sell real estate can review a purchase and sales agreement and somewhat understand its terms. It has been designed to be understandable so that people don't need lawyers to understand it, but it's still, at the end of the day, it was still written by lawyers. It's still legalese, as we like to say. It still has complexity to it, and I just think that, and again, this goes back, this kind of dovetails very nicely with the first tip, which is to utilize an attorney to represent you. Even if you cannot afford to have an attorney represent you from pillar to post, or from the beginning of the process to the end, then at least engage the services of an attorney on an a la carte basis to have him or her perhaps review the purchase and sales agreement with you and on your behalf. If you were to limit their legal representation to that one task, I think you would find it to be very affordable. I mean, it might be a little more than you would spend taking your family out to eat at a nice restaurant on a Friday night. And I have 4 kids, so I know all about how much that can cost. And I think that if you were to engage the services of a real estate attorney to just review your purchase and sales agreement, I think it would probably be comparable to that night out on the town with your family. The third tip, and I always have to remind myself and remember to smile, because this is, even though I get very serious and I get almost maniacal about these issues because I have such a passion for it, it's supposed to be fun, and so I always have to remind myself to smile just to kind of loosen things up and lighten things up a little bit. The third tip that I want to have this is for buyers, purchase the owner's title insurance. Some people watching this video may not even know what that is. If you're entry level on real estate, which I think is wonderful, everybody's got to start somewhere. The biggest real estate moguls in the universe started with a simple purchase of a piece of real estate. And that purchase led to purchase number 2 and number 3, and now maybe they own 10,000 properties, who knows. So you got to start somewhere, and everybody's got to start with that first one. But my piece of advice for buyers: buy the owner's title insurance. Now, this was much worse a couple of years ago. A couple of years ago, when this market was basically spinning out of control, you would have some, lenders kind of advising buyers, well, you got to pay for the appraisal, and you got to pay for the lender's title insurance. Of course, the lender is going to mandate that you get that. You've got to pay for your escrows. You've got to fund your escrow account. You've got to pay the prepaid interest. So everything was presented, all of the fees and charges, you got to pay to record the documents. You got to pay transfer taxes. So every fee was represented as being no way around it. You got to pay this. And then, of course, they would get to the owner's title insurance, and they would put that reassuring arm around the buyer or the borrower and say, now that's a big number, but that's optional. You actually don't need to get that. And of course, how do most people in that scenario respond? Well, I got to pay this, I got to pay that, I got to pay this, I got to pay that, but there's this one thing on there I don't have to pay if I don't want to, and that's a big number, so I guess I won't. And so I saw a lot of people not buying the owner's title insurance for that reason. I also saw situations where people were being charged an exorbitant amount for fees. And again, this is just a different time and a different climate and a different atmosphere, but I saw situations where lenders would just charge exorbitant fees to the point where the buyer didn't have any money left to buy the owner's title insurance. And the psychology of it became that because it was optional, the buyer didn't need it. And it was the first thing to be thrown overboard when the buyer was kind of scrambling to get their figures nailed down and to make sure that they had sufficient funds to close. I've seen that situation. And I've just seen the situation where somebody anecdotally, reads something online about title insurance, and it's just this great big ripoff, and nobody should ever get title insurance. And then that anecdote gets exchanged at the barbecue or the holiday party or whatnot. And next thing you know, somebody walks into a room with a very limited understanding of title insurance, if they have any understanding of it at all, but they heard from somebody that it's just this great big ripoff and they don't really need it, and so they shouldn't buy it. That's a myth. It's a mistake. I have personally purchased, I don't want to overstate it, but let's say multiple properties. I've always purchased the owner's title insurance, and I'd like to think that because I'm a lawyer and because I'm in this business, I could probably figure out how to solve and rectify and remedy some title defects without invoking coverage under my owner's title insurance policy. I mean, I could prepare an affidavit, I could prepare a letter, I could call a lender, I could find a document, and even I, with my skill set, have always consistently purchased the owner's title insurance. So it's not a scam, it's not a ripoff. And of course, there's lender's title insurance, and you can never borrow money if the lender isn't getting title insurance. So what does that tell you? If you were to propose that the lender, if you were to propose, and again, this is sort of a fanciful example, this could not happen, but if you were to call the lender and say, I'm deciding that I'm not going to get the owner's title insurance because I don't think it makes sense, and somebody told me that I don't need it, I don't think you should get the lender's title insurance either, because I'm going to save some money on the owners, I'd like to save some money on the lenders. The lender would basically say, look, I'll break it down for you. If you're not getting lender's title insurance, then we're not making the loan, and it's that simple. So think about a situation. How could somebody possibly say to you that you don't need the owner's title insurance when you'll always get the lender's title insurance, and if you weren't going to get it or you objected to it, then the lender wouldn't make the loan. It's not a ripoff. It's not a scam. It's important. It's needed. It's necessary. Does everybody need to invoke their coverage under their owner's title insurance policy? No, they don't. But for those people who do and do not have the policy in place, they are on it's a very hard road for those people. It's painful financially and otherwise. It's frustrating. It's confusing. It's almost like having a fire at your house and finding out that you don't have the insurance. People are running away from you. You are so on your own. Like, it's no different with title insurance. And when I call up major underwriters, major title insurance companies to try to navigate through a title insurance issue, the first question that I'm always asked, so as soon as they pick up the phone and we start to delve into the details of the matter, the first question that I'm asked, Do they have an owner's policy? And that's all anybody wants to know. And the reason why that's all they want to know is because if they do have an owner's policy, we need to help them. If they don't have an owner's title insurance policy, we don't need to help them. And it's just that simple. It's like that proverbial kitchen fire. If you have insurance, you're all set. If you don't have insurance, you are not all set. You're in trouble. And it's the same way with title problems, title defects, and title insurance. So get the title insurance. Ask the attorney to take a discount on something else. It's like that. It's like those commercials for Boar's Head, which I love. Of course, I love that food too. But they say compromise elsewhere. I think that's their tagline. I love that. When it comes to title insurance, cut something else. And I don't know what that something else is, because a lot of these fees can't be cut. They can't be negotiated. You're not going to make a lot of friends in real estate if you go looking for discounts, because most of the work has been priced pretty aggressively anyways. I just think that, is the owner's title insurance optional? Yes. If you don't get it, are you making a mistake? Yes. You're making a big mistake. So my advice for buyers is when presented with the option, and it is an option because it's optional, of getting owner's title insurance, you should always purchase that coverage. We can't cover title insurance in this seminar because this is really just about tips, but we will. We have, and we'll do it again because it's important, and I don't want to be advising people to get something that they don't understand. So we'll do another video on title insurance, and we'll have some fun with it. What to review at a closing. I've seen this 100 times. Maybe I've seen it 1,000 times. Inexperienced buyers walk into a closing room. It can be a stressful place. You've got buyers, you've got sellers, you've got lawyers, you've got realtors. We're all huddled together in a little conference room. Sometimes it's hot, sometimes it's crowded, sometimes there are kids running around, and the buyers are facing a dilemma. If they're inexperienced buyers, if this is their first home. And the dilemma is that the closing attorney or closing agent is basically going to put a stack of documents on the table about that thick. And the dilemma becomes, okay, we know we can't read everything. And let me just say right now, and we'll do a video on closing psychology, because there's a psychology to this, and I understand it better than anybody. The dilemma is, you can't read every document. If you did, it would take hours. And I'm telling you right now, that's never going to be okay with a room full of people that expect the closing to take no more than an hour. A closing should really take no more than an hour. It's what we budget, what we budgeted for. If realtors and lawyers are scheduling closings, they usually allow for about an hour. So 2-hour, 3-hour closings, these things are unheard of unless there are major issues at the table. But a reasonably efficiently paced closing involving people that know what they're doing should take about an hour. You can't read all those documents. You, meaning a buyer, cannot read all those documents in an hour. And I think buyers take stock of the situation. They see the documents in front of them, and I think instinctively they know that. Like, I can't read all that stuff, but I have to sign all that stuff. Okay? I'll squeeze in another tip 3.5 or whatever number that we're at. I think it might be at number 4, but we'll make sure we get a few more in. If you are the type of person who just cannot bring yourself to sign a document unless you've read it, and those people are out there. I did a transaction involving a priest who I know trusted me. And I told him he didn't need to read everything, and he still did. He said, my father told me once, don't ever read a document, don't ever sign a document unless you've read it. And I just think there are people that are cut from that cloth, that's part of who they are and what they were told, and it's what they do. So if you are, and you know what, that's totally legitimate. If you are one of those people, this tip's not for you, because I'm going to tell you what you need to look at, and that you don't have to look at everything else. So you could almost discard this entire tip. If you are the kind of person who needs to review every single document that you sign, have the closing agent send you the package the night before or the day before the closing, so that in the comfort of your own home or wherever you live or you're living, you can review the document package in its entirety. And then you can show up, you can take whatever steps you need to take to ascertain that the documents haven't changed, I mean, the wording is boilerplate, but make sure it seems to be approximately the same document package that you reviewed, and you can sign with reckless abandon because you will have already reviewed the documents. So for those people that need to read everything, get the documents beforehand. Please don't put the realtors and the sellers and the lawyers and other parties to the transaction through the agony of watching you review documents for 3 hours when that is just not our customary practice. That's unusual, it's unconventional, it's at odds with the scheduling considerations that have gone into this process, and I think on some level it's unfair. It's unfair to force people to sit in a room uncomfortably and watch you review documents when there is a way for you to review every document beforehand if that's truly what you want to do. But for those, and then of course there are buyers that sit down on the other side of the spectrum and they instantly realize they can't read everything and that maybe they shouldn't try. And so in some respects they don't read anything. And because it's associated with people that have never been through a process before and essentially do not know what to do. And they don't want to walk in and say, what do we do? Because people just don't want to do that. People don't want to ask stupid questions or questions that they perceive as being stupid. They don't want to transmit to people that they're inexperienced. Maybe they want to try to, create an appearance of strength or resolve or experience or wisdom. And so there's just, for a million different reasons, buyers walk in, sort of take stock, and try to make some very quick, private executive decisions about how to get through the closing. And so I've seen it being that people are reviewing everything. So we always wind up with the polar opposites. Either people review too much, which makes the closing take too long, and they really don't know what they're looking for anyways. So they're just reading, excerpts from documents and whatnot. Or people read too little, and they just sign, you almost wonder if the document had somebody else's name on there, would they catch it? Because they're signing almost, I would never accuse of anybody of signing too fast. And I think people that sit down and just sign away have accepted a very pragmatic reality, which is that if you don't sign the document, you can't get the loan. The only time we can ever change anything is if it's wrong. So even if you found a provision in a document that you didn't like or you didn't feel was in your best interest, you can't change it. You can't cross it out and initial it. It's non-negotiable. If the closing agent calls the bank and says, yes, I'm with Mr. and Mrs. Jones right now, and we're signing the documents, but they don't like paragraph 9 of your compliance agreement, the lender would say that basically gather up all the documents and cancel the closing. So I think the buyer that sits down and just signs away has accepted a reality of their situation, which is that they have to sign everything. If they don't sign something, they won't get the loan. And so let's do our job here and get this done. Okay. I'm going to sprinkle a little something in there. There are times when there are mistakes in the documents. It actually happens a lot. It's unfortunate. And the mistakes don't get caught because people aren't reviewing the documents carefully enough. Now, the mistakes do not appear in the densely worded, pre-printed provisions of the documents. That stuff, again, we can't get rid of that stuff. Where the mistakes occur is the custom features of the transaction. Names, property addresses, what county is the property in, what's the loan amount, what's the interest rate. Mistakes can be made with these things. I've seen people's names spelled wrong. If names are misspelled at the closing and those spelling errors are not rectified, it can create headaches down the road. If your name is misspelled in a deed, let's say that your name is John Smith, and your last name is spelled S-M-I-T-H, which I guess is probably the conventional spelling of that name. But the closing attorney misspells your name and they spell it S-M-Y-T-H. Okay, and you don't catch it, or it isn't caught. Do you realize, or you should know, or the viewer of this video should know, that every time you do anything with this property, you're always going to be known as John Smith, the way your name is spelled correctly, also known as John Smith, the incorrect spelling of your name from the prior transaction. So it's a hassle. It's a hassle, and it's sloppy work, and it shouldn't happen. I mean, how can we possibly conduct a real estate transaction if we don't even have people's names figured out? I mean, we can and we do, is the truth of the matter, because mistakes get made, and that's the way things are. But these are avoidable mistakes. So it's been a lengthy prologue, dramatic buildup, but here's the tip. These are the documents that you absolutely have to review at your closing, okay? And you don't need to review anything else. Review your HUD, which is the ledger, the settlement statement that has all your numbers. You got to review that document. Review the promissory note. Make sure that the interest rate is right, that the loan amount is right, that the term is right. If you got a 30-year or a 20-year or a 25-year, do some quick math in your head to make sure that the maturity date is indicative, that the term of the loan is what you think it is, okay? It doesn't happen a lot, but I see lenders every now and then get that wrong. And you know what? If you sign a promissory note and the interest rate's wrong, it was supposed to be lower and you can prove it, the lender will probably do the right thing after the closing and reduce it, because that's just the environment that we're in. Fair is fair. So if you were supposed to have 3.5%, but the promissory note at the closing said 3.75%, and you didn't catch it, and the closing attorney didn't catch it, the lender will go back and make that right, as long as that's what you were supposed to get and you can prove it. But it can happen. So review the HUD. Review the promissory note. Here's another one, more obscure. If you're escrowing, which means if you are paying taxes and insurance as part of your monthly mortgage payment, review the escrow account disclosure statement and make sure that it's right. This is a trap for the unwary, and this is the mistake that I see a lot of real estate lawyers make because of the complexity, and it's something that's easy to screw up. But if you are escrowing for taxes and insurance, then you need to be paying a monthly amount into your escrow account to cover the taxes and the insurance. Two issues. Number one, make sure that you're escrowing a sufficient amount, which means make sure the closing attorney or title company has accurately and correctly determined what the annual taxes are and what the insurance is. I've seen this get messed up because somebody made a mistake. Maybe the taxes are $6,000 a year, but the title company or closing attorney miscalculated them at $3,000 a year. And so the escrow is, maybe $200 and some odd a month when it should be twice that amount. And you don't find that out until your bank goes to pay the taxes or the insurance and they find out they don't have enough in the escrow account. And then the miscalculation comes to light and they have to go back to you and get it from you and they have to increase your monthly payment. And again, it's a hassle. So, and then the other issue is that if you are closing in March, you probably have, well, taxes are twice a year in New Hampshire, by and large, with some exceptions, and they're quarterly in Massachusetts. And so it really depends where you're buying or selling. In Maine, typically also twice a year. It's different everywhere, and not every town is the same, so it's the kind of thing that you should always look into. But typically what will happen is if you are closing, let's say that we're in Massachusetts and we're closing in April. There's a tax bill that's going to be due in May, and that tax bill really should be collected at the closing, so that when that tax bill hits, even though it's probably before you'll make your first mortgage payment, it needs to be paid. It needs to be paid either at closing or it needs to come out of your escrow account. Look at the HUD. Look at your escrow account disclosure statement. Make sure not only are they escrowing a sufficient amount to pay your taxes and insurance, but make sure if there's a tax bill coming up that it's been established how it's going to get paid. There's nothing worse than closing on a home, getting a tax bill in a month, and saying, oh look, there's a tax bill due right away, and realizing after the fact that it wasn't collected at closing, and your escrow account is not paying it because they're not scheduled to make the first escrow payment until the next tax bill or the next insurance bill, which means that you have to reach into your pocket and you need to basically pay that tax bill out of pocket. And it's usually not a situation where you're paying something you shouldn't have to pay, but it's just the inconvenience and the surprise of being told kind of on a moment's notice that, hey, there's a tax bill due. It's a pretty significant amount of money, and it's due now, and even though you're escrowing, it's not in your escrow account, and even though they usually collect it at closing, they missed it, so they didn't, and it's just like somebody being asked to pull, $2,000, $3,000 out of their pocket on a moment's notice, on short notice, and for most people that's difficult, and that's usually a product of the escrows being messed up. And look at your payment letter. Find out when your first payment's due, who are you paying. I mean, many times if you go to a local bank, you're going to be paying the bank. You can sometimes walk into the bank and make your payments at the branch or at any other branch. Other lenders are making the loan, but the loan is going to be sold right away to a servicer, which is the company that's actually going to receive your monthly mortgage payments. So I would look at the payment letter. I'd be clear as to when your first payment is due and what your obligations are there. Am I going to be paying the bank? Am I paying this other bank? Should I get an invoice from that other bank? What are my auto pay options? Can I do automatic withdrawal? Can I do, can I do bill pay? I mean, the bottom line is, to what I'm saying, you want to make sure that if your first payment's due on February 1st, that you make your payment on or before February 1st. And so confusion and uncertainty and who's my bank or where do I send my payment, those are the only things that could prevent you from making your first payment, your first mortgage payment in a timely manner. So when you're sitting down at the closing, make sure that you have reviewed the necessary documents, your HUD, your promissory note, your escrow account disclosure statement, and your payment letter and the details around the payment of the recurring payments of your mortgage and how you're going to do that in a timely and efficient and convenient manner. And so basically we've already done a few tips here. The first tip was hire a lawyer, which we've talked about. Have a lawyer review your purchase and sales agreement was number 2. Number 3, for buyers, purchase the title insurance. For buyers, the documents that you need to review at the closing. Now I want to throw in another tip for sellers. Sellers will sometimes, and one other thing that buyers should review, we've touched on this in other videos, this is so important. Review the deed. And we've talked about this before. The deed is probably the most important document in that whole stack. In that whole stack, the deed is probably the most important. And the deed doesn't get signed by the buyer, it gets signed by the sellers. So the buyer can be like up to their eyeballs in legal documents and never even see the deed. Insist on seeing the deed and insist on reviewing the deed before the closing. Any mistakes in the deed can condemn you to months, sometimes years of frustration, and they got my name wrong in the deed, so now every time I sign a document, they've got my right name and my wrong name, or we had to get more deeds done, or we had to do a deed with a neighbor because this lot wasn't included, or they included something they didn't want to include, and so that has to be deeded back. It's a hassle. It can be expensive. It can be time-consuming, and it can take quite some time to unsnag some of these knots that are created by problems with the deed. So, and what frequently happens at closings, again, the psychology of the closing process, is the buyer is just busy signing their lives away, or life away, or buyers signing their lives away, and then the deed gets sort of nondescriptly handed to the seller. I mean, the seller is basically signing the deed, signing the documents, they're getting their money, and they're moving on. So I think an educated seller will know that, hey, I need to review this deed because if it's not done right, I'm going to get a phone call, and they're going to want me to do another deed, or a new deed, or a corrective deed. So I think an educated seller realizes that it's not just a question of, well, none of this affects me anymore. When I walk out the door with my check, I'm gone. Yeah, you may be, but you may get a phone call, and you may sign documents at the closing obligating you to sign other documents or additional documents if it's needed to make this process correct. The seller, in some cases, will just sign the deed, hand it back to the closing attorney throws it in their pile, buyer never even sees it, but ultimately is stuck with any problems created by it if it's done wrong. And that's a document that's not a form. So, I mean, you can say, how does an attorney screw up a form? Well, it's actually pretty hard to screw up because we get a lot of the closing documents from the bank. We don't create them. Once upon a time, the attorneys created all the documents, and for some clients we still do, but mostly all of the closing documents come from the bank. The attorney doesn't have a hand in preparing them. The deed is different. The deed is a document that's actually typed start to finish by the law office handling the closing or by the seller's attorney. So it can have typographical errors, names spelled wrong, it could have street instead of avenue, or vice versa. It could be missing lots that are supposed to be included. It could have lots that are not supposed to be included because the seller already sold that lot to somebody else or they're keeping that lot for themselves. And depending on the quality of the people preparing the document and the quality of the office that you're dealing with, I've seen deeds with tons of mistakes. Name spelled wrong, wrong lot, wrong street, wrong address. And because it wasn't proofed by any of the people involved, the mistakes went unnoticed and had repercussions for everybody. But anyways, to conclude, the fifth tip, For sellers, you don't have as much to review. Review your deed. Sellers, it's a truism of the closing process that buyers have this much to sign and sellers have this much, and that's true. I'll give, because if the buyer's going through a bank. If a buyer's paying cash, then they both are signing about the same amount of documents. But when you're borrowing money to buy real estate, the bank is making you sign a lot of their documents, and it's significant. So the seller will be done signing probably in 15 minutes when the buyer will still be, working on it for 45 minutes to an hour. So the seller could legitimately review everything they sign, even if they don't have an attorney, because they'll have time to do it because the buyer just has so much more to sign than they do. Having said that, if you want, as a seller, if you want to economize, I would say review the deed. If you have a mortgage payoff, a mortgage that's being paid off, ask to see the payoff. Make sure the payoff has been done correctly. The payoff will basically be the payoff of the loan through the closing date, and typically a couple of days in addition to that, because it'll take a day or two for the payoff to be processed and credited and all that good stuff. If there are utilities that are being collected, whether it's trash, sewer, water, whatever the case might be, association fees, make sure those prorations have been done correctly on the HUD. Final water's correct, final sewer's correct. If there are taxes that are being apportioned between the parties, which is not uncommon. So if the seller, let's say we're doing a closing in January, and it's January of course, and the seller has paid the taxes through the end of this month. Well, if we close tomorrow, then the seller needs to be reimbursed for tomorrow through the end of the month from the buyer, because the taxes are already paid, but the buyer is going to live there. Those reimbursements and prorations need to be checked for accuracy. They're frequently wrong. That's the amazing thing. I guarantee you, and I hope this isn't true, but I suspect it is, that if I were to review 10 settlement statements from 10 different closings, at least one is going to have the taxes wrong. At least. And it might be higher than that. It's scary to contemplate, but it could be 2 or 3. Now, when I say wrong, I don't mean somebody is paying thousands of dollars more than they should be paying, or they're, those big obvious mistakes usually reveal themselves because people's numbers are just so far off. They're bringing more to closing than they thought, or they're getting way more back, and honest people will speak up. So it's not, we're not talking about thousands of dollars, but sometimes we're talking about hundreds of dollars, and I think most people would agree that that kind of money is worth policing and saving. So pay attention to your prorations. So these tips, these 5 tips have taken a little bit longer to deliver than I thought. It's probably made for a long video, hopefully not a boring video. But I think the most important thing is to hire a lawyer if you're buying or selling real estate. Have a lawyer review the purchase and sales agreement for you. Even if that's all they do, it's a contract, it's binding. You have rights and obligations pursuant to that document. You should understand what they are. If you're a buyer, buy owner's title insurance. You got to buy that. You got to compromise elsewhere. I don't want to get sued for trademark infringement. Cut elsewhere. Let's put it that way. It's like the Boar's Head commercial with the compromise elsewhere, which I love. Cut elsewhere. Cut something else out. And I know there's not a lot to cut, and again, you're not going to make a lot of friends if you go looking for discounts because everything's already been priced pretty competitively. But just find a way to justify getting it. And it's cheaper if you buy it at the closing. So some people will rationalize, well, I can't afford it now, but I'll get it in a month. If you get it in a month, or you get it in 2 months, or you get it next year, it's going to be more money. It's cheaper when you buy it at the closing as part of the lender's title insurance. Documents to review. Nobody knows what to review, so people either review everything, which you really can't do and you shouldn't try, or they don't review anything, which I don't think that's entirely responsible. Buyers, review your HUD, review your note, review your payment letter, and review your escrow account disclosure statement, and review the deed. Sellers, review the HUD, review the deed, review all of your documents, of course, but pay special attention to your payoffs, your mortgage payoff, that's very important. And also utilities. How is my mortgage going to get paid? When is it going to get paid? How much is owed? And these utilities. Have all these utilities been done right? Did they do the water right? Did they do the sewer right? Did they do the trash collection right? Sometimes utility charges are paid in advance. If the seller has paid them, then they get a credit. If they haven't paid them, the buyer gets a credit. Again, these are the kinds of things that we work with on a regular basis, but mistakes are part of the human process and the human condition, and to err is human. So knowing that, as I do, as we all do, it's possible that a mistake will be made, and if you have the right team in place, you'll you'll find these mistakes and they'll be rooted out, and you won't have to live with them beyond the closing. My name is Len Foy. I'm a real estate attorney in Nashua, New Hampshire. I thank you for suffering through this long video. I'm kidding, of course. Hopefully you haven't suffered through it. But hopefully you've enjoyed it and you found it useful. Anybody who's wishing to consult with me, all consultations are at no charge. Call my office, send me an email, schedule an in-office appointment. We'll sit down, we'll go over your project, whether you're buying, selling, or refinancing real estate in New Hampshire, Massachusetts, Maine, or Rhode Island. We can help. I can help. We're on the World Wide Web, www.foylawoffice.com. My phone number, if you want to call me, is 603-598-4030. If you want to send me a fax to kind of get the ball rolling, our fax number is 603-598-4020. And lastly, if you want to send me an email, you can email me at lfoy@foylawoffice.com. Again, Happy New Year. I hope all of your dreams come true, and that this is an amazing year for anyone watching this video. And I'm always filled with optimism this time of year, because I just strongly believe that it's going to be a great year for all parties concerned. And thank you for watching my video, and I hope to hear from you. I would love nothing more than to be your attorney and to represent you in your real estate transaction.